11:48 a.m. at your residence. And page 16, lines 6 through 9. You want to read that, or you want me to read it? Excuse me?
Can you read, please?
Sure, I'm glad to. Investigator Ford goes, why? Did they seem like they were looking for a fight or something? And you go, basically, yes. So, does that refresh your memory concerning what you told Investigator Ford about these two people wanting or looking for a fight?
Yes, sir.
Okay, and is that what happened? To you, it looked like they were wanting or looking for a fight.
Yes.
Do you remember what they were doing that led you to believe that they might be looking for a fight?
Yes, sir.
Now, while you were out at the Sugar Bowl, was there any conversation with Mr. Leverett or Mr. Riley about whether or not you or Kendra or maybe even Wayne Greenlaw wanted to purchase some Loratabs or some type of drugs?
No.
There was no conversation regarding that.
I don't remember.
Now, since this incident has occurred, have you ever had any contact with Justin Ryle? No?
Seen him at the store once.
Excuse me?
Seen him at the store once.
Saw him at the store once, but that's the extent of it. Now, when you left the Sugar Bowl, did you take Kendra directly back to your house? Or did you stop by the Greenlaws first?
Yes, we stopped back by their house.
Excuse me?
Yes, we stopped by the Greenlaw house first.
Now, you also mentioned when you got to the Greenlaw house, you saw Ray Greenlaw out in the yard or out in the driveway area waving a machete, correct? You have to answer all that.
Yes.
Okay. And did you see Wayne Greenlaw outside?
No.
Now, you had made some reference to the fact that at some point in time you saw Wayne fire warning shots. Is that correct?
Yes.
And do you know what kind of weapon he had when he fired the warning shots?
Did he 16?
Excuse me?
Did he R16?
Did you ever see Wayne Greenlaw shoot a 9mm in the air?
No. It could have been that.
Excuse me?
It could have been a 9mm. It was dark outside.
Okay, so when you saw the warning shots, you're saying it either could have been the rifle or it could have been the 9mm.
Yes, sir.
Is that what you're saying?
Yes.
Because you didn't get a good view of what the weapon looked like.
Yes.
Is that correct? You have to answer out loud.
I said yes, sir.
Now, when you first started your testimony here today, Mr. Will was talking about you didn't want to be here, that you didn't want to testify. Is that correct?
Yes.
And would it be fair to say that you were arrested last Friday afternoon because there was a warrant out for your arrest for your indicating that you weren't going to come to court and testify?
I wasn't coming to court. That day, never getting a court date.
I'm talking about coming to court and testify in this case.
Okay.
Excuse me?
Well, I've mentioned what you said.
Okay. Isn't it true that you were arrested last Friday
Yes.
on a warrant because there had been indications that you were not going to come to court and testify in this case?
Yes.
Right. And isn't it true that at the time that you were arrested on the warrant for indicating you weren't going to come to court here and testify in this case, that at the same time you got arrested because they are alleged to have found drugs on you?
What does that have to do with this case?
I'm asking you a question. isn't it true that at the time that you were arrested on the warrant for not coming, for indicating that you were not going to come to court and
Yes,
testify?
sir, they found two Xanax in my pocket.
Okay. And so then you got arrested for that too, correct?
Yes,
And isn't it true also that following this particular incident, you have been charged with burglary of an unoccupied dwelling?
correct. I've been facing it. I've been fighting my charge for a year. They still haven't found no evidence against me. So.
I mean, the case is still pending,
Correct.
and that case is pending here in Volusia County, correct?
Correct.
Right. And you're being prosecuted by the same state attorney's office that Mr. Will works for, correct?
I guess so.
And are you aware that if you were to be convicted of burglary of an unoccupied dwelling, you could get up to 15 years in prison, or up to a $10,000 fine, or up to 15 years probation, or a combination of fine, probation, and jail time?
No.
You didn't know that? All right.
It was stopped me 24 months.
24 months, oh, they made an offer of 24 months Department of Corrections?
Yes.
And when was that offer made?
A year and a couple months ago.
About a year ago, and you rejected that offer?
No,
In other words, you told them you didn't want to take the 24?
they kept continuous. That wasn't me. They won't let me talk. They continuous because they have enough evidence. I don't know what's going on. They keep continuous themselves. The state keeps the continuous in it.
And you understand that if you were convicted of this charge, you could become a convicted felon too, correct?
Yes.
I don't have anything further. Thank you, Mr. Searles.
Re-examination, Mr. Wood?
Please. Hello again, Mr. Searles. Feel any better about being here?
Yeah, it's getting this over with.
You just still don't like it much, do you?
It's been a lot easier if I came here myself.
Yes, it probably would have, sir. I think this morning, while you've been testifying, we've all had difficulty determining which statements you made when you were sober and which statements you made when you were drunk. Right?
Correct.
And those are all your statements, right?
Sir.
You gave a large number of them the morning that this occurred. You gave a large number of them the afternoon that it occurred, both when you were under the influence of alcohol, right?
Yes, sir.
And then you gave a deposition on January 31st, 2012 that you weren't, right?
Yes, sir.
And this morning, after you helped us make this distinction, the defense attorneys asked you about the deposition, and they asked you also about the statements where you were drunk.
Yes, sir.
And I even played for you the statement that you made to Investigator Fortman when you were drunk, right? You heard it.
Yes, sir.
Okay. Do you dispute that that was your voice?
That was me.
Do you dispute that that actually occurred?
Apparently did. I'm on there.
Do you dispute the truth of what was in that statement? That Ray Greenlaw was in the front yard waving around the machete and yelling down the street, "Come on."
No.
Okay. And you made that statement even though you were drunk. And it was accurate. And it remains accurate today. In fact,
Object, Your Honor, this is improper language. The accuracy, that's what the jury did.
I'm not hearing it, sorry.
Excuse me?
I wasn't hearing very well.
Okay, I object to one in questioning regarding accuracy. That's what the jury did determine after they heard testimony.
There's a standing objection to rephrase the question.
Oh, well.
Word accurate.
yeah. Do you stand by that statement today?
Yes.
And so not only was it your recollection back then, but it's also your recollection as to what occurred as you sit there right now.
Yes, sir.
Now, I'm only going to talk to you about your deposition. I'm not going to ask you all those things that are in your drunk statements, okay?
Sir.
So let's just talk about your deposition. You still got it there in front of you?
Yes.
Okay. Is it all right if I just read some portions of it to you and you tell me if you remember it?
Yes, sir.
I'm going to turn to page 48 of your deposition. You can turn along with me if you like. You don't have to. I'll read it to you.
Yes,
At the point where we get to page 48 of your deposition, I was there, right? You remember being there on the 31st of January of 2012?
Yes,
You remember Mr. Ballerino being there?
yes.
You remember Mr. Lawrence being there? Do you remember all three of us calling you a liar?
No,
You don't remember all three of us sitting there saying, Scott, quit lying to us?
I think so. I would want to believe so, yes.
Okay. Now, on page 48, I'm going to read you a section where Mr. Lawrence is talking to you. And he says, Scott, what we're trying to do here is just get to the truth. And listen, I'll be honest with you. If it hurts my client, it hurts my client. If it hurts Ryan's case, I'm sure Ryan will tell you the same thing. He just wants the truth. We're just trying to figure out the truth about what happened. And then I say to you, Scott,
Your Honor, can we approach and make an argument on this last?
I'll ask that the jury be taken just into the jury room for now. No. Everyone may be seated. Mr. Ballerina, the basis for your objection.
Yes, Your Honor. I don't have any problem with what you said. What I have a problem is Mr. Will then goes, the last thing I want to do, Scott, is prosecute an innocent man, especially for something as serious as murder. I think that's totally improper. It puts the integrity of the state attorney office behind this prosecution. I realize they're prosecuting the case. But first of all, we believe since we are here and that we are in trial, that this being read to the jury, Mr. Will saying the last thing they want to do, Scott, is prosecute an innocent man, especially for something as serious as murder, is something that should not be presented to the jury.
You have no
In
problem
his
with
personal opinion.
You have no issue with anything except for that statement?
I
Or
have-
that question, whatever.
Then the witness, I don't know how far he plans on going, but the witness, Mr. Searles, goes, he ain't innocent. I didn't tell you that. I don't know if they were trying to get that in, but I waited, when I saw this page, I waited to object when we got to the part that I was concerned about. I don't have any problem with what he just read, but I do have an objection to the remainder.
Mr. Will?
I considered reading that portion of my statement to him. The last thing I want to do is prosecute an innocent man. And then further down the page, you just need to tell us what happened. So if there's something that you're not telling us, something different than what we told, what you've already told us, we understand. This is the time to fix that. After you walk out the door, you don't get to fix it. And that was the conversation that was had with Mr. Searles. We've called into question here his truth and candor in this proceeding, both through the direct and the cross-examination of the witness. This is an attempt to go back and rehabilitate that to some extent and get into the merits of the deposition as opposed to the drunk statements that were obvious lies to some degree.
Mr. Lawrence, do you wish to be heard in any manner?
Well, Judge, to be honest with you, I think it's inappropriate to do it, even talking about the truth. There's a statement that's attributed to me. This is in a deposition, and the court knows that all things that are in depositions aren't necessarily admissible in court. And one of the things that I say in that statement that he just read to the jury is that if it hurts my client, so be it. Well, that's something we can say in a deposition that shouldn't be said in court. So I have an objection to that part of it. I surely have an objection to the part about you ain't innocent. I didn't tell you that. Now the part where it says that I understand we're trying to make decisions about what happened, I don't have any problem. Because that doesn't refer to me trying to say something that hurts my client that I said in the deposition. And that statement that we're talking about up there is my statement, Mr. Lawrence. So that's my problem. I'm making this statement in there. And so I think it's inappropriate, that part of it, but
Is that the one dated January 31st, you said?
Yes, ma'am. Page 48. Lines 7, essentially through the end of the page.
and I will tell you this, there's no doubt all three of us were sitting there at the time and, going, well, this, we're trying to get him to try to tell us what he remembered truthfully, but I think even then he was having problems with his memory, so that. But the statement attributed to me, I think, is what I object to, and then the part about he ain't in, so.
You're only attempting to get in, Mr. Will, through page 49, line 3.
Just line 1. Well, yeah, through line 3, excuse me, yeah.
I mean, it's not a question to him unless we get his
Right.
response.
Yeah.
I will sustain the objection in part and overrule it in part. Obviously, I need to put these numbers farther away from the seam of the folder. Lines 14, 15, 16, 17, 18, 19, 20, and the first two words of 21 cannot be read.
Okay.
But picking up on line 21 with, you just need to tell us what happened, through page 49, line 3 will be allowed.
Okay.
Any further comments, questions?
No, you're
All right.
That's a
Bring the jury back in.
question.
Jury. Jury may be seated.
Everyone else may be seated. Ladies and gentlemen of the jury, the objection was a peremptory objection for things that were coming up. So there's nothing that you heard that won't be allowed to be asked, and I just limited certain things that would be allowed to be read from the portion of that deposition. So I sustained the objection part, overruled it in part, and counsel will comply with that ruling and may continue.
Yes, ma'am. Do you remember the portion of the conversation I just read to you? Okay. And do you also remember the portion of the conversation that followed where I said, Scott, you just need to tell us what happened. So if there's something that you're not telling us or something that's different from what you've told us, we understand. This is the time to fix that. After you walk out the door, you don't get to fix it. And you remember what your response was? I know, I'm trying to say it the best I know. Does that sound familiar? And you were in fact trying to say it the best you knew in this deposition, were you not? But there were still some things that are different than what you said today, right? Okay. Now, for instance, one of those differences comes on page 29 of your deposition. So I'm going to turn over there, and you can too if you'd like. On page 29, you talked about your drinking on this particular night. Now, here in court, do you remember when Mr. Lawrence questioned you just a little while ago about drinking? Do you remember that you told him that you had somewhere up around, I think his math is around 72 beers.
Yes,
Do you remember that number?
yes,
Okay. Do you remember what you told us in your deposition about how much you drank that night?
that's true.
Okay. I'm going to read it to you. You tell me if this sounds familiar to you. Starting on line 12. How much did you drink that night? Your response a couple lines later. I'd say 3 or 4 cases. Between how many people? 4. Actually 3. My old lady drinks 2 or 3 beers. And you heard Mr. Lawrence mention that about the 2 or 3 beers,
Yes.
right? But the rest of this is what followed. So between 3 people, you had 3 or 4 cases. Yes, was your answer. Do you remember that?
Yes.
Okay. And then I ask you again. So from 4 o'clock in the afternoon until 4 o'clock the next morning, you drank about a case and a half of beer. And you said yes. And I say again, so you drank 36 beers in about 12 hours. Is that correct? And you say correct. Does that seem familiar to you?
Yes.
Okay. And so that's different than what you talked about with Mr. Lawrence. When he asked you about whether you had 72 beers, what you told us back then when you were sober is that you had 36.
I'm going to object as to a mischaracterization of what the evidence was. I didn't contribute 72 years. I asked the exact same question that Mr. Whittle did. And
I'll sustain the objection. The jury is instructed to listen to the questions, the responses given, the comments on what they mean. That's for you to decide what it means. So I'll sustain the objection to that extent. You may continue, Mr. Wilk.
And then I want to go over to page 15. But before I do, I want to talk about the beers. You think 36 is about the right number?
Yes.
Let's go over to page 15. Actually, before I do, let me go somewhere else. Hold on 1 second, please. I want to go to page 24 of your deposition. And I think today that you've testified under cross-examination, both to Mr. Lawrence and to Mr. Valerino, that these 2 guys were causing problems out at the lake. Is that correct? Now, I'd like you to look at page 24 of your deposition. And we're going to go down through the bottom part at 21 all the way through to the next page, okay? You want me to just read it? Okay. Now, these guys, Brian and Justin, that were out at the lake, did it look like, were they aggravating you? Were they causing any trouble? Were they getting on your nerves? Anything like that? Do you remember what your response was to the deposition?
Yes.
What was your response to the deposition?
Yes.
Actually, it was no. It was no, they weren't. And then we go on to the next page, and we ask you, well, what were they talking about when you guys were out there at the lake? You know, Kendra and these 2 guys. Just stuff. And you're asked, what kind of stuff? Do you remember what you said? Okay. You said, like stuff that friends would talk about. We acted like we knew each other for a while there, but we really didn't. I guess we thought they was good people, apparently. I don't know. That's a lot different than what you told us in court today, isn't it?
Yes.
Yeah. Can you explain that difference to us?
Yes, sir.
You were sober back then at your deposition, weren't you?
Yeah.
Okay. You're sober here today.
Yeah.
And I think what you testified to next is that you got a call around 4:30 in the morning, and I don't know what you did, because you told me that you didn't go to the Greenlaw's house, but you told both of them that you did go to the Greenlaw's house. So what'd you do?
They both are papers also.
Oh, they read those papers from when you were drunk, didn't they?
Yes.
Okay, let's talk about what you said when you were sober at your deposition.
Yes.
You think that's probably a better indication of what happened?
Could be.
Could be. I'm going to turn to page 34 of your deposition. You can turn with me if you like. And we're going to talk about what you said at your deposition when you were sober. page 33, at line 25, you say, I dropped Kendra off. And it goes on to page 34. And so on page 34, you're asked, so you dropped Kendra off, you hung out at your house for a while. Yes. What did you do when you hung out when you were at your house? Just hung out. With whom? My old lady, fiance. Just Kendra. Yes. Inside or out? Inside. What are you guys doing there? You talking? Watching TV? Just watching TV. Anybody else in the house? My mom and Jamie went to sleep. I know they was sleeping. So you sit over there for hour and a half, you think? I guess so, yeah. We was watching a movie. It was Law and Order. What was it? Law and Order. On to the next page. When you get to the Greenlaw's house, Ray is in the front yard with the machete, correct? And you say correct. Okay. So let's talk about that for a minute. When both the defense attorneys were up here today, they were talking with you about your statement when you were drunk, right? Okay. And they questioned you about, I think, an 8-minute gap where you had been at the Greenlaw's house, drove Kendra home, and came right back. You remember that? Okay. How is it that you were only gone to drop Kendra off for 8 minutes if you never went to the Greenlaw's house and you watched TV for an hour and a half? Okay. So we got a problem there, right? Yeah. And over again in this deposition where you're sober, you say you never went to the Greenlaw's house before dropping Kendra off, that you went straight from the woods, straight to your house to drop off Kendra. Do you remember just saying that? Okay. And that was when you were sober. Yeah? And so we got a problem as to whether you went to the Greenlaw's house or whether you didn't, don't we?
Yes.
In fact, one of the places where you said that was page 37. Did you go there before you dropped Kendra off? Referring to the Greenlaw's house. Oh, excuse me. Did you go there before you dropped Kendra off? Yeah, me and her did hang out and watch TV. That's referring to your house still, where you were watching TV with her, right?
Yes.
A little later on the page. Question. Did you and Kendra go back to the Greenlaw's house after you were out at Dry Lake? Answer. No. Question. Or did you take Kendra straight home? Answer. What do you think you said?
I took her home.
You did. You said, I took her home. My mom called me because she wanted to go back to sleep. Next question. So then you drive back over to the Greenlaw's house. You know what your answer was? Yep. Now, a little while ago, when Mr. Lawrence and Mr. Valerino were questioning you, they brought up some questions about whether the victims had been there once, or they had been there twice, or they had been there more than that. Do you have any evidence of how many times Brian Lever and Justin Riley were there that night?
No.
Were you even at the Greenlaw's house?
When?
Any time after you ran into Justin Riley and Brian Lever?
I think so.
And so you really don't know what happened over there that night,
No, sir.
right? But over the course of the night, you've told us already here today that you had in excess of 20 calls with your good friend, that father figure, Wayne Greenlaw. Is that accurate?
Yes.
If there had been something going on, if there had been a major problem over at that house, do you think you would have remembered it in all those 20 telephone calls between you and your father figure, Wayne Greenlaw?
Yes.
And yet somehow it never came up in your deposition, did it?
No.
And it hasn't come up here today. And in fact, if there had been such a big deal in this last telephone call that you guys had at 4:36 a.m., you probably would have gone over to his house, wouldn't you?
Yes.
At 4:36, right? I mean, you would have gotten in the car, quit watching Law and Order, and driven to that house in a hurry, right?
Yes.
Okay. But you didn't do that. You told us in your deposition, you're telling us here today you watched Law and Order for an hour and a half. Right?
Yes, so.
And when you did arrive back out at the Greenlaw residence is when you saw Ray standing in the driveway, waving the machete and yelling down the street. Right?
Yes.
Now, Scott, Mr. Searles, there are a lot of things here where you both answered yes to me and yes to them. And so, let me ask you this. Is your memory really that great?
No.
Are there certain things that everybody can agree upon in your statement so that we can try and figure out what happened?
Yes.
Certain things like Ray Greenlaw standing out in the front yard waving a machete,
Yes.
yelling and screaming down the street, "Come on, come on."
You know, I'm going to object to this line of questioning again. It's just something for the jury to decide. He's admitted that his memory is not that great. It's up for the jury to decide what he recalls accurately and what he doesn't.
However, Roll, I think he's trying to get, and I'll give you all an opportunity, should you wish, to examine based upon Mr. Will's examination. But I think it's appropriate to ask him what he does remember and what he is committed to based upon his testimony here today. He may answer the question.
Are there those certain things that we can agree upon that you can remember did happen?
Yes.
Let's start with those, okay? Let's just forget about all this other noise and let's just go through those. You went to Wayne Greenlaw's house and you drank beer at 5 o'clock in the afternoon.
Yes.
You proposed to your girlfriend out by the bonfire later that evening.
Yes.
You borrowed his Jeep and you went out to the dry lake.
Yes.
You drank some more out there.
Yes.
At some point later in the evening, you received a call from your mother
Yes.
saying, "Come on back. It's time for you guys to come home."
Right.
Between the time that you arrived at the dry lake and the time that you got the call from your mom, you ran into Brian Leverett and Justin Riley.
Yes.
You don't really know whether they were good guys or bad, do you?
Right.
But nothing sticks out in your memory as to a fist fight between the two of you.
No.
Somehow, they end up over at Wayne Greenlaw's house.
Yes.
You don't remember inviting them,
No.
but somehow they ended up there.
Yes, sir.
You don't know how long they were there.
No.
You don't know what happened inside that house while they were.
No.
All you know is that at 4:30 in the morning, you received a call from Wayne Greenlaw. Right?
Yes, sir.
That after dropping off Kendra and sitting around at the house, you got that call. Right?
Yes, sir.
And that you were watching Law and Order for an hour and a half or so with Kendra
Correct.
after receiving that call. Right?
Yes.
And that when you showed up back at the Greenlaw house that morning at 5:30 or so, that Ray was out in the street waving a machete. Or out in the driveway waving a machete.
Yes.
That Ray was shouting into the darkness about, "Come on, bring it on."
Yes.
That at some point, within just a few minutes, Wayne Greenlaw had a conversation with you, right?
Yes, sir.
Okay. And we got to that in your deposition as well. Page 25 in your deposition. Did Wayne try to get you a gun when you got to the house? Again, did Wayne try to give you a gun when you got to the house? You say here, no, it was Wayne's brother. You say, Wayne's brother tried to give you a gun? No, he gave Wayne's brother a gun. And so there you're telling us that Wayne gave Ray a gun, just like you told us earlier, right? On to the next page, 27. Did you see Wayne give Ray a gun? Yes, and he followed behind him, and he had, it looked like a 9mm. Is that pretty consistent?
Yes.
And you saw Wayne come out of the house carrying a rifle? Yes. And page 15, your deposition. When you got to Wayne's house, where were they? Referring to the victims. I didn't see them. I just seen Wayne's brother, Ray Greenlaw, standing out in front of the garage door with a machete in his hand, and I didn't know what was going on. Then Ray Greenlaw came out with a firearm, and I seen him walk a couple houses down, and the gun went off. So we can agree on that, right? Okay. Page 22. So did you see the fight, any kind of fight that took place between anybody? No, I didn't. Do you agree with that? And you come back to the Greenlaw's house after everything's already over pretty much, page 33 of your deposition. Well, not everything is over. You come out and Ray is holding a machete in the front yard. Correct is your answer. We agree on that, right? Page 37 of your depo. I was talking to Wayne, and Wayne was flipping out. Question, now who is in the house when you get to the Greenlaw's house? Answer, I just seen Wayne and his brother. Wayne's brother was sitting on the couch, and afterwards, I seen him with the machete when he was standing there in front of the garage door. Do you agree with that?
Yes.
Now let's talk about why Wayne's flipping out, page 39 of your depo. Okay. You're in the driveway with him. Question. Answer, yes. He had a 9mm. He was shooting it up off in the air in his driveway, and then he walked back in the house. I followed him, and I seen him grab the gun. I was trying to stop him, and he pulled out a 9mm, and he tried to hand it to me. And I said no, and he put it on the bed. Does that sound right?
Yes.
Okay. On to page 40. Why was he freaking out? Why was he getting guns? He said them two guys came down the street over here and just barged in the house for no reason. You recognize that?
Yes.
Okay. Page 41. Did anybody make any, or I'm asking you here, did they make any statements about wanting to kill someone? No. You're saying no there. And I say again, Mr. Searles, they never said, let's go kill these MFers when they handed you the gun. You say, huh? And I say, they never said, let's go kill these MFers when they handed you the gun? And you say, correct. They did, come to think about it. And you testified to that here today, right?
Yes.
Okay. And you agreed that that happened back then, that when they handed you the gun, they said, let's go kill these MFers.
Yes.
And I ask you who said that, and you said Wayne's brother said that. And I say Ray, and you say yes. And I ask you, what did Wayne say to him, to Ray? And you say, let's go. And that's when you put the gun down on the bed and said that you didn't want to have any part of this? Yes. Do you go outside to see what happens? Yeah, I made a phone call. And then the green truck pulled up, I threw my bike in the back of the truck, and as we were pulling away, they're walking back to Wayne's house, meaning the two defendants, the two brothers, are walking back to the house. And I asked you, did you hear all the gunshots? And you said yes, before the green truck pulled up. And I asked you, did either of them ever tell you why they were arguing with the other two guys? And you said no, they didn't. And I said, did they ever tell you that the other two guys, and then the question's cut off, and you say you actually did, that they barged in their house and that they had been uninvited. And that's the idea that you gave us as to what started all this.
Right.
And so we can agree on all of those things, can we not?
Yes.
But there are a lot of things that, whether it's because your memory fails or because you had a lot to drink that night in everyday sense, we probably shouldn't rely upon your statement. Is that correct?
Yes.
And some of those details are how many times the victims came to the house, right? And whether or not there was an argument out at the lake.
Yes.
In fact, whether or not you even invited them back to the Greenlaw's house. Is there anything else that we can agree upon here before I stop asking you questions? Anything else that you're really confident about?
Sorry.
Anything else you feel like I've put any words in your mouth today?
No, sir.
And we just went through your deposition when you were sober, right?
Yes.
I didn't ask you questions about when you were drunk.
No.
Anything else that you can think of right now and think, gosh, I'm really sure on that point. Let me tell Mr. Will before he stops talking.
No, sir.
Thanks, Mr. Searles. I appreciate you talking with me.
Thank you.
I just want to ask, from a timing standpoint, I'm going to give counsel an opportunity to examine Mr. Searles further, but I just need to know approximately how long you think that will take.
I think mine's gonna be very short.
Okay? And you may continue.
Mr. Searles, you've heard the questions that Mr. Will asked you about your deposition, right, just a minute ago? And he got you to go through all these things where you agreed. Do you recall how this started with him asking you about what happened on page 48 of your deposition?
No.
Well, didn't he tell you that on page 48 that all of us were in the room together taking your deposition? He was in the room, and I was in the room, Mr. Ballerino was in the room. And when we got to page 48, he said here earlier that all of the attorneys told you that what you were telling us was a lie. Do you remember him saying that earlier? Well, he did. And all the questions that he just got through asking you, not a single one of them occurs after page 48. Do you know why it was that all of us were going, where are you getting this stuff from? Because none of that did it, Mr. Searles, matched up with what you had previously told the police or anybody else did it.
No.
So all this stuff that he just took this time to go through, line after line after line after line, we stopped in the middle of this deposition and went, where is this coming from? told us in the deposition, you may have been sober. But you weren't telling us the truth, were you?
Yes, sir.
The fact of the matter is, sober or not, this deposition that you gave to us on January the 31st of 2012, by agreement of all the attorneys sitting in that room, was a lie. Now, what is true, drunk or not, is what I went through with you earlier of what you told the police. Isn't it?
Yes.
Now, you know, over the years I've learned you take your witnesses as you find them. Drunk or not. But I'll tell you this, on the afternoon of the morning when all this happened, was the clearest you were at any time since this event took place about the facts of what took place. Wasn't. You were drunk out of your mind on that morning. But by the afternoon, you were a little bit better, and all the stuff that I went through with you earlier was in reference to what you told the police. Told the police, not me. Not Mr. Will, not him, not them. What you told the police that afternoon, right?
Yep.
January the 31st of 2012 was just a waste of time, wasn't it?
Yep.
Kind of like the one we took with you last week. Remember? At that deposition on January the 31st of 2012, we stopped right after that because we just basically don't want to talk about that. And we reserved, Mr. Ballerino and I did reserve the right to come back and take your statement later, hoping that your memory would be better. We did that a couple weeks ago, didn't we?
Yes.
How did that work out?
Apparently that's good.
Follow-up question.
Mr. Ballerino, any additional questions?
No additional questions, Your Honor.
All right, does Mr. Searles want to get the council's position on whether or not he should be released from his subpoena? Mr. Will? Mr. Lawrence?
Yes, ma'am. You can be released. I'm sure there's no objection.
All right. Subject to the instructions I've given to the court previously, if council agreed to being released from his subpoena, he is released. Mr. Searles, I do need to advise you of a rule that is imposed by the court. You are not to discuss your testimony here today with anyone until this trial is over. You may continue to talk to the attorneys if they want to talk to you, but you can't talk to anyone else about your testimony here today. If you were to violate that order, the court could hold a criminal contempt of court proceeding and you are found guilty of that, sentence you to 6 months for violating my instruction. Do you have any questions?
I do one question for you. My one, I'm guilty.
That's not my issue. You're being released on my no bond warrant
right,
as a
right.
result of your testimony being done and completed.
No problem.
All right, ladies and gentlemen, at this time, we'll be taking our lunch break. I'll ask you to return at 1:30 for continuation this afternoon.
Fire.
Yeah, if he's available, I'd like to talk with Mr. Howard if he's available. You said back at 1:30?
We'll ask them to come back. If you all aren't back, they can sit in the jury room until you're done, but you can
Okay.
start at 1.
Okay.
What time is it? I'm sorry.
I told the jury 1:30, but if you're not done, they can be accounted for and brought into the jury room, and you all can complete, and we'll start when you're ready.
Okay.
As soon as possible after 1:30.
We'll do our best.
Okay.